Can I look at, right? All right. All right. Good afternoon, everyone, and those that have joined the CCMA on our very first Facebook Live submission, and acknowledging that we have received a lot of interest from members of the public. For purpose of introduction, my name is Cameron Morajane. I'm the director of the CCMA. Before we start with the festivities and the formalities of this process, I would like to request us to take a moment of silence because we have noted from the stats from the Department of Health that we are sitting with 8,232 infections, and we now recorded 161 deaths as at this morning. And for that purpose, I think it is in order and also very respecting and appreciation of the circumstances that we're in that we take a few seconds moment of silence. Thank you. This is a very important submission. As you can see, I'm fully armed with my gloves. I have my mask. We have social distancing between me and my team. I can also confirm that our offices at the 28 Harrison at the head office, together with a few offices at this stage of the CCMA, they are being disinfected, deep cleaned, and there's provision of the PPEs that are necessary for the purpose of operation of the CCMA. We have seen with interest in Gauteng in particular that the Premier Makhura announced that they have ordered 64.4 million of PPEs, and they've already received about 10 million of that. I'm sure that as we proceed as a CCMA, as you will note from this presentation, that we will take interest in ensuring that the CCMA and all its 24 offices, it is fully compliant when it comes to a COVID-free environment. Ladies and gentlemen, the CCMA family, this is a very important submission, and this is in response to all the submissions that have been made by the different ministers, particularly Minister Nkosazana Zuma, also the Minister of Health, Kabaza, and also our Minister Utula Singesi, and also this morning, which was quite an important and impeccable timing submission before this submission, the Minister of Public Service, in relation to what is expected for us to move forward. In dealing with this submission, we are going to try our best also to respond to the questions that we have received from the members of the public, with just one proviso, that when it comes to certain technical questions that we know for sure that they are still pending in the hearings of the CCMA, we are going to take a very cautious approach in order to ensure that the interest of the CCMA, the interest of the parties, both the employer and the employees, is not compromised by what we say in a public platform. We do not also want to influence our commissioners in dealing with certain questions that will be coming before them as they conduct the proceedings. But to a large extent, we will be in a position to respond to some of the questions that we thought are very important. The questions that we have seen, we have noted that members of the public have actually missed the CCMA and its function. And I'm sure that you'll be excited to see some of the submissions that we're going to make in order to respond to the pertinent questions and dispense justice. So to that extent, we will be cautious, but we will answer the questions to the extent possible. Ladies and gentlemen, when it comes to this submission, it comes at a time when there are a number of external factors, both domestic and international, that are affecting the operations of the CCMA, our sister entities in the Department of Employment and Labor, and also that is affecting the bargaining councils that we as the CCMA accredit. I can assure you that most of the things that we have done to date and that we'll be doing moving forward, we will try to synchronize them within the Department of Employment and Labor and the public service in general. This will include the Essential Services Committee and the bargaining councils of the CCMA. As we start, it is quite saddening to note that there is a prediction that given the COVID-19 and its impact, that there is a predicted 40 to 50% unemployment rate that may happen in South Africa. If our unemployment rate reaches the 50% mark, it will be quite unprecedented. As I will submit and argue that when we look at the rate of unemployment as a people in a constitutional state, in a country that is doing its best to grow economically so that we can become a member of the family of nations, as we see in the international arena, that we will have a percentage reaching 50% of people who are unemployed. This will put pressure on government's efforts to make sure that we deal with the triple crisis. Noting that, it is also with sadness, and I will touch on the issues of the large-scale dismissals and ordinary dismissals. But we have also noted, because the CCMA has been operating, except that we did not take face-to-face entrances to all our 24 offices, but behind closed doors, the CCMA was not closed, but it did not operate at full strength. That's why we're able to receive applications online and be able to process them. We have been unable to set matters down at our offices because we were sitting at level 5 lockdown. We have noted with pain that a number of companies that have approached us, that companies are closing. Those that are largely affected are those that are small and medium. We have seen that bloodbath. This is the bloodbath that the CCMA has been talking about for months now. Business, organized labor has also noted that inevitable circumstance. As the CCMA, because we're an institution of justice that is expected to provide social justice, we are privileged, albeit not pleasantly, that we do receive requests for facilitation of certain labor market related cases, particularly Section 189 and Section 189, capital letter A. I shall touch on that. I've noted also in the international reports that 90,000 of pilots worldwide will be without employment. I've noted also, amongst others, Togo-san, for example, the South African Airways, ComAir, that they are undergoing a business rescue. And in some cases, like in the hotels, which is hardest hit, they're experiencing high numbers of retrenchment. I shall return to that later. Not only is that, as we present, we've noted in terms of the labor market forces and activities that the South African Revenue Services is anticipating that they will have 280 billion rand shortfall in terms of revenue collection. As a public entity, we should take serious interest in such a shortfall because it's not just a shortfall, it will have direct impact on service delivery. And for us to provide the kind of assistance that is being provided to our members of the public through the COVID-19 UIF fund and the measures that were introduced by the president. We know that the UIF funds are under pressure or probably even depleted because of the high demand that the minister has spoken about and requests and assistance or relief that has been granted to businesses that are under stress. I shall talk about that later specifically because there are questions that were asked in relation to that. It is sad that small businesses are closing because small businesses are one of the biggest productions of our employment, and they are contributing in reducing our unemployment rate. But if they are closing, it means our unemployment rate will then start to soar. It is quite an acute problem that needs an integrated approach for us to be able to assist and improve. We also noted that South Africa has been rated down by the rating agencies. We do understand that the rating agencies' grading has a direct impact on the credit worthiness of our South African economy and our government as a company. That we also take with pain. We also noted our rail company, Prasa, is also reporting yesterday that they are also anticipating or actually suffered a 200 million rand loss. That is very serious. We also noted that there is a looming load shedding, as noted that it is actually expected that we might have load shedding. The load shedding, in our view, in some of the measures that we're going to introduce, we are going to be negatively affected in terms of the new processes that we're introducing in order to improve our accessibility and also to achieve the expeditious resolution of disputes. We know that there's water shortages, and of course now we are sitting with the COVID-19. Ladies and gentlemen, please note that CCMA did receive, during the lockdown, applications in terms of Section 189A in as far as large-scale dismissals, because that's what it means. We also received referrals in terms of retrenchments, those that are not large-scale. But the bottom line, they are both dismissals based on what the law calls operational requirements, commonly known as no-fault dismissals. Just purely on the lockdown process, we've experienced 17 referrals on the large-scale dismissals, which is affecting 3,344 employees. We've received the normal Section 189A, which is not large-scale, which is 151 referrals. Of that, 133 is employees retrenched, which is affecting 1 employee. So in total, on the low-scale one, we have 303 dismissals. But I must emphasize something very important here. These numbers that I've just read are not a true reflection of the actual dismissals that are happening in the labor market. Small-scale dismissals, operational requirements, usually are not reported. There's no referral for unfair dismissals. There's no request for us to intervene to try to assist to the extent that is possible. Therefore, the numbers that you see also are directly affected by the fact that the CCMA offices were on level 5 lockdown. But we are aware, because we've received all these requests for people to refer. They don't want to use the online approach. They wanted to come to our offices. We've noted the numbers, which are not reflected in our case management. But I can say for certain that the moment we open our offices, as we will be doing, we will be receiving huge numbers of this type of disputes. But it's not the only dispute that we're expecting. There are other ordinary unfair dismissals where people state that they want to come to the offices, not sending them by fax, not sending by email. I will also comment about the dismissal of the domestic workers, which has been trending. It's one of the dismissals which, when we became aware of, when it was reported by the media, that there are cases of about 40,000 that are being referred to the CCMA, we verified that those cases are cases that actually occurred even before lockdown. And we take everything into account, we're verifying whether the numbers are actually 40,000. But as it is expected of the CCMA, before we even deal with those cases in terms of our system, we have requested our commissioners through the dispute resolution of the CCMA to intervene in resolving those disputes, which we have done. And we're receiving a report on the progress that we are making in that regard. So when the doors are opened, I can assure you that the numbers are going to look completely different because our offices were locked down in terms of level 5 lockdown. Let me go specific now on the impact of COVID-19 in the operations of the CCMA and also, of course, the bargaining councils. In terms of COVID-19, this is a new entry, this is a new normal of the CCMA. We also expect a different type of a commissioner. Just to name a few. Number one, because of COVID-19, which will be with us for some time, we expect that our commissioners, not only will they be dealing with cases that are at our offices, we expect our commissioners to also travel to the different workplaces to do matters such as unfair labor practice cases, the Section 188 capital letter A, which is the inquiry by an arbitrator, and fair discrimination cases. Those type of cases are cases of relationship, and therefore it is befitting that such matters were practical, that we send or deploy commissioners to go and deal with those matters there instead of just having those cases at our offices. That is a new normal, so that one is going to increase. I will also talk about what we call a tech savvy commissioner. This is a commissioner who is technically savvy and be quite comfortable in dealing with the new system of recording that we have, the web-based hearings, which is a new entry, which I will talk about later. And sometimes when we use our trainings, we'll use our webinars. So when a commissioner, therefore, is a commissioner who is a techno-savvy commissioner, he will be able to provide this service. We believe this new approach will ensure that we access workplaces, that we expedite resolution of disputes, and we make it less costly and less stressful. So the CCMA is preparing to make sure that we do that. Please note that when it comes to web-based hearings, we have already started doing so. Parties have agreed because that is a process which is exactly based on consent. Because it's still new, it needs to be managed properly. So it's gaining momentum where a hearing is heard on Zoom, it is heard, well, despite its problems, it's also heard on Microsoft Teams, where parties are sitting elsewhere other than in offices. We're going to produce a directive on exactly how we will be dealing with matters that are web-based. Now, we also expect our commissioners now to be more of specialists in terms of processes. This process we've already started so that they can give better service to our users. And we expect our commissioner to be absolutely up to date on the happenings in the labor market, including developments in the area of law, both in terms of case law and statute. What is most important, especially in the context of COVID-19, that commissioners are expected to care. We want to develop caring commissioners. We should be more caring during the COVID-19 pandemic because the country and the world is subjected to the brutality of the coronavirus. And we therefore will be ensuring that our commissioners in dealing with matters, especially those that arose during the COVID-19, that they deal with them with care. And I must also emphasize, when it comes to the relationship of employer and employee, that we expect that our commissioners to act with dignity in dealing with those issues. In the matter of dignity, I'm going to deal with it on the certain types of dismissals and conduct that we've experienced during COVID-19. Let me proceed then to talk about, in terms of COVID-19 approach, the venue aspect. There are very important issues and developments in as far as how we're going to deal with the hearings. To the extent that parties agree, the workplaces of employers will be used for hearings. Secondly, the CCMA offices will continue to be used as well. There'll be resources that will be made available for those that prefer to use our offices or unable to attend to web-based or other alternative methods of doing hearings. So that is going to be still available. We strongly believe that as an entity of government, and that is operating on a budget allocated from the FESCAS, that all state venues and buildings should be accessible to the CCMA also to be used for purposes of hearings. So moving forward, we're going to partner with government departments, particularly Department of Employment and Labor, in ensuring that we use those venues for hearings so that people don't have to travel a lot, don't have to spend money. If there's an office of the Department of Employment Labor, we must use that for our hearings as well, including the web-based approach. And we'll be using also the offices of our stakeholders and social partners, which they've agreed to, at least at the board of the CCMA, that such venues shall be used. And we shall deal with that, particularly on how we're going to deal with that. The hearings definitely will be heard at plant level. I think this is a question that is directly asked by Johan Braces. I hope I'm pronouncing your name correctly, Brace. He asked the question on whether cases will be heard at plant level. The answer is yes. There will be cases that will be heard at plant level. And I want to make this special call to all employers and employees in organized labor that if there's a matter like the Section 188A or an unfair dismissal case, it is acceptable. There's absolutely nothing wrong, especially when both parties are comfortable and agree that the cases be heard at the premises where the matter arose. We will deploy a commissioner to come to your workplace, provided that the occupational health and safety issues and corona-free environment is met. We will deploy the commissioner. It is exactly what I spoke about when I said that we're going to have traveling commissioners during COVID-19. We will give him the gloves, we'll give him sanitizer, we'll give him a mask and say, go and resolve a dispute. You are the CCMA commissioner. So parties, witnesses, don't have to travel, spend money, be on the trains, be in the taxis in order to go to a case and expose themselves to a virus or the coronavirus. Our view is that when you're dealing with coronavirus, we must not make a mistake of thinking that when we're talking about COVID-19, that is the only virus or a disease that is affecting the labor market. We've got TB, hypertension, sugar diabetes, cancer, which are serious killers of our people. COVID-19 just added to the problem. So when you're talking about a COVID-19 free environment, it does not mean the other diseases must exist. It must be free of that. When a commissioner comes to your workplace, he must come there assured that he will not infect your staff, that your staff will not infect him. But in this way, we believe that we are doing exactly that the workplaces are a place of social justice. And we are deploying our commissioners to come and do cases there. Now, the issue of the web-based, let me deal with that. Firstly, the web-based hearing at this stage, it's going to be consent-based. In other words, for us to do the web-based hearing, either on Zoom or on Microsoft Teams, the employer and the employee, or the applicant and the respondent, must agree that this is the process that we want to do. The cases that are currently running, all of them, based on web, have in fact been consented to. All we have to do is to make sure that the materials, like a Wi-Fi, must be present. It must be stable, it must be uncapped. That is very important. And then secondly, if you don't have Wi-Fi, you see, when I spoke about the load shedding, this is what I meant, that it may affect this kind of a process. If there's a load shedding, your Wi-Fi will be affected and the connectivity will be affected, then the matter will be badly affected. So those factors are important for it to properly work. And I must add that we did not just lightly agree to that. So Stephen Kester, this question that you asked about whether the web-based process will affect the witness credibility, no, because when you're doing a web-based hearing, it is an AV process, the audio and the visuals. I know that in some cases, because of the load, because of the pressure on the data, that the video takes up a lot of data. I do understand that in some cases, that you may find that the hearing is conducted purely on the audio, but not the video. But the web-based, we strongly recommend that the video must be used so that when a union official or the employer's representative want to cross-examine a witness, they must be able to observe the conduct and be able to test the credibility of the witness. The web-based hearing must in fact reflect in content and character the same type of features that parties will enjoy, which they would have enjoyed ordinarily if they were doing the office-based or the CCMA office-based face-to-face hearing. There must not be any prejudice. I can assure you that we've tested case law on the side effects that may be associated with web-based hearing. One of the questions that comes up is exactly what Kester asked, whether the credibility of the witness will be affected. We will going to develop specific guidelines and practice directive on how to properly conduct web-based hearings, because this must just be seen as a new platform of doing cases where there's no possibility of infection. You don't have to worry about social distancing. You don't have to worry about the mask and gloves, because everyone is way beyond 1 meter or 2 meter social distancing, because there is no face-to-face contact. We are going to perfect it. We're going to make it work. But I'm calling upon employers, unions, and government that when we do this web-based hearing, please provide effective and sufficient tools for this web-based hearing to work effectively. I'm very glad that the Labour Court has also introduced the web-based approach, which effectively means the character of the evidence that we deal with now moving forward is not just about the transcription of a documented transcript. You now have the video evidence, wherein possibly when you're dealing with matters at the Labour Court, where you wish to see the conduct of the witness during the actual hearings, you can have the access to both the audio and the video because it was based on web. We know that the systems Microsoft Teams and Zoom can record, so it is stored at the cloud. So accessibility is not the issue and the credibility is not the issue. So we're very excited that we're going to do so. And this is based on a very strong uncapped Wi-Fi or data 4G or 5G that is being used, because the last thing we want is for that process to be interrupted because parties have run out of data or Wi-Fi is down. Now, the question is, when is, according to Dominic Fagan, please, I apologize if I pronounce your name badly. Dominic Fagan is asking, when is the web-based starting? It has started. As I said earlier on, as we speak, matters are running now that are web-based. But what we need, at least for you to do, is to make sure that both parties agree that the matter be web-based, that the technical aspect and the host of who will be hosting must be made very clear, because we need to ensure that there is no such an interruption. But if you both agree, and no matter is pending at the CCMA, please send us a consent form or an agreement between both parties, like other parties that have done even yesterday, where they said, we agree, web-based, that's the way to go, that's the new normal, that's how we're going to do it. So in answering your question, Dominic, we've already started. If you are interested that you want to do the web-based hearing together with your opponent, just send us that consent. We will deploy the commissioner and let's talk about the setup of the Wi-Fi that is uncapped, which will make it stable. That does not run out of data, because if it runs out of data, then the process will be severely affected, which will then lead to postponements and delaying that and costing more to run that case. If one party does not agree, Michael Killian is asking the question, what if the employer does not agree to the web-based? Then we will not do web-based if the employer does not agree or one of the parties does not agree. At this stage, it is still based on consent. I cannot say for certain that in future, once we've established this practice within the context of 4IR, that it will not become peremptory. Because remember that in terms of Section 138 of the Labour Relations Act, the Commissioner has the power on how the matter should be determined. But at this stage, it is not compulsory. If there's no consent, there is no web-based hearing. Let me proceed, and I'll continue to deal with the questions as they come as well. The other important thing to note, which I'll deal very quickly, the CCMA took a decision with my executive team and the governing board of the CCMA that the call center of the CCMA be decentralized. In other words, our central call center, which was sitting at 28 Harrison, will now be at the different provinces. We found it quite uncomfortable that if you call the call center sitting in Johannesburg and wanting to ask a case that is dealt with in Mpumalanga, then it gets redirected back to Mpumalanga. We want you to be able to call directly to the province where the matter is being dealt with. What we're going to do, which is what we're doing now, that we're going to have an automated system that if you're calling and you're giving your case is sitting in other provinces, you should be equally to be redirected. For example, if your case is in Gauteng, it's a GAGP case number, press 1. Press 1, then it directs you to the Gauteng province. If it's Limpopo, press 2, it will redirect you there. That system is what we're installing now and providing that service so that all of you, if you want to access the CCMA, you should not struggle to do so. So it is confirmed that it is decentralized. We wish to apologize that in the past few weeks, we have had serious problems with this transition into the decentralized system. Some of you have tried to call the CCMA, and I heard that some of the calls were not answered. It was because of these transitional arrangements that we are talking about. We are hoping in the next 2 weeks that we'd have sorted it out. From next week, I will talk about that, what happens, but I can assure you that we'll be back in business and without glitches. Now, the question of when will the office be reopened, I will deal with that, right? I will deal with those questions. Now, let me talk process. Number one, please note that today, latest tomorrow, we are going to publish new directives on how we are going to operate, inclusive of some of the matters that I am talking about now. Secondly, all matters that are capable of being resolved through papers, it's going to be dealt with that way. For example, if somebody is applying for condonation, that matter can be dispensed without parties appearing before a commissioner. You submit your application, the other party's answers, the applicant replies, you submit your heads of argument, the commissioner makes a ruling. So all matters that are capable of being resolved through the submission of stated case or applications with affidavits will be dealt with without it being set down for people to travel and expose themselves to coronavirus. This is a matter that we are taking very seriously. This will also include the condonation applications, for example, the Rule 25 issues and issues of certain type of cases that are dealing with pay disputes, which I will comment about as we progress. Now, that is settled. So most cases that ordinarily we would set down, even though it can be done on paper, now will be exclusively done on paper. Rulings will be issued in terms of the statutory requirements. Nothing has changed in that regard. I shall answer the question dealing with condonation also, because that's one of the questions that has arisen. Now, in terms of referrals, I can confirm to you that during the course of this week and the week starting between the 11th to the 15th, we are not yet accepting entrances to our offices of face-to-face referrals for that week. The week of the 11th to the 15th of May, it's a preparatory week, it's a trial week. That is the week next week. That is important to note. Now, here's a very important announcement based on the question that was asked by Charmaine Gray and Mariette Riedelanghuys and Tessa Fortune. When will the CCMA offices reopen? Mariette Riedelanghuys, I want to pronounce that correctly, and Tessa Fortune have asked this, and Charmaine Gray, Nathan Williams, have asked this question. When will the CCMA office reopen? Right? Number one, let me give a direct answer. In the week after next week, which is the week of the 18th, if I'm correct, the week of the 18th, right? The CCMA offices are going to reopen. right? Yeah, the week of the 18th of May. Let me confirm that. In the week of the 18th, that's week after next, right? Next week, the week of the 11th to the 15th, it's a week where we are doing a few things, which I will talk about now, right? It's a preparatory week, basically. The web-based are continuing, the paper matters are continuing, the referrals are coming through the other alternative methods. So that is settled, there's no confusion. The face-to-face referral of cases, the face-to-face hearings of the CCMA will take place in the week of the 18th of May. So that's the direct response to the questions of our colleagues who asked that question. So next week, the week of the 11th to the 15th, we are doing the following things. Number one, all the offices of the CCMA are being disinfected. Even in the office I'm sitting with now has been completely disinfected. They're deep cleaned. PPE is provided with sanitizers made, gloves provided, mask provided. That is secured. That is done. It is important to note that. So that is the preparatory. The issues of marking on the floor on the social distancing is being done. All the issues that the Minister of Health, including the Minister of Public Service and the Minister of Labour have talked about what we need to comply with, will be done in that week of next week to make sure that when we welcome you, you are safe. When we open offices, our staff is also safe. What we don't want to do, why we're approaching it this way, this is in compliance with the incremental introduction of services, right? That we're doing this slowly. Our managers and certain critical functions will be back to work next week. This does not stop you from doing the other alternative referrals of cases using our platforms. By the way, we are also developing digital referral forms so that when you want to refer, you don't have to use the hard copies because that can also be contaminated by COVID-19. That we use digital forms for people to refer cases. So that question is settled. And now, the web-based hearing, of course, will be continuing. Nothing will stop. I've already responded to that matter. Now, there's a question that says, will arbitrations in May and June continue? What about those from March? Will they be prioritized and rescheduled? Let me respond to you this way. There are matters that came before the COVID started, and there are matters that were referred during the lockdown. The matters that were referred before lockdown, as you can see, they are already in the system. They are being rescheduled to later dates because we were awaiting for us to reopen the offices. And they follow that queue in terms of priority. We will not have cases that were referred during lockdown coming first, and those that came before that are then having to wait. Logically, it will not be fair for those cases to wait in a queue when they came first. So we're going to follow that process of matters that were there before lockdown, during lockdown, and continue to set them down. When you see a note that says cancelled, please do not panic. When it says, if you get a note that says case cancelled, please do not cancel. Matters are rescheduled. They're not cancelled. They're not removed from the roll. They're not dismissed. There are no special applications that must be made for that matter to be set down. That's what we do ordinarily. And you're going to see more of that next week. So you will see that before the end of May, matters will already be sitting down. There's going to be time blocks because we need to deal with numbers. The 1/3 that is set, we're going to comply with that because we can't overload the CCMA. We have to do this incremental. The last thing that we want is to have our users who are negative in as far as COVID-19, but leave our offices COVID-19 positive. We will never do that to you. What we are asking you to do for us also, that do not come and infect if you are COVID-19 positive. That is why we are going to apply a very stringent and disciplined approach in how we deal with queues, on how we deal with paper referrals, and the time zones that we'll be setting for matters to be heard at the offices of the CCMA, but the web-based one will continue, as I've already said. So that is the direct response on the arbitrations. But please note, and this is a very special call I'm making to all parties who have referred cases to the CCMA. Please remain alert on phone calls that will come from the CCMA on matters that are sitting on conciliation and con-ups. because we are going to attempt to maximize the pre-conciliation processes using a telephone. When we make phone calls during lockdown, many of our users who referred cases did not respond to our calls. I'm pleading with you to organize labor and organize business that you're going to receive that 011 number, 012, depending on the province where the matter is going to be, where a commissioner will be online to try to conciliate a matter that you have referred between yourself and your employer. So we can only successfully do so if you answer your phone. And our records reflect that pre-conciliations that we've conducted have been very successful, especially those matters that involve domestic workers and farm workers. But the pre-conciliation processes are not only limited to that, but help us for us to be successful to expedite the backlog by answering the phone and meaningfully engaging with the commissioner in an attempt to resolve matters on the telephone. So pre-cons are very important. They're available. They will be happening this week, even next week, and the week after. It's going to become a common feature because we have to deal with COVID-19 and avoid face-to-face contact. There's a specific question that comes from Francisca Moises and Dominic again. Dominic is very busy. Dominic Fagan again. We're not discouraging you. We appreciate that, Dominic. The question is, have all CCMA offices been disinfected? Yes, I have confirmed this earlier on. Let me say this and show you why this is serious. Lives of people, whether it's a worker or whether a CCMA employee or any person for that matter, you cannot come clean without the coronavirus to the CCMA offices and be infected, and then take the virus back to your family and infect everybody else. Work is important, but work is not more important than life. The CCMA offices, if they were not disinfected, they would not be open. We would not have opened offices if disinfecting and PPEs are not provided. That is why you must note that if you come to the offices of the CCMA, you're not wearing a mask, we will not allow you into our premises. We will not allow any user, when we open in the week of the 18th, to enter any of our 24 offices without you wearing a mask. This is intended to protect you, to protect other users, to protect the CCMA. So our surfaces are being deep cleaned, they are being disinfected, we're providing all the PPEs that are necessary. That is why it was important for me to mention that the Premier of Gauteng has ordered 64 million units. The CCMA will continuously order our PPE equipment so that every interpreter, every case management officer, every commissioner, every staff member of the CCMA will at all times wear a mask. And for those that deal with papers, they will always wear these gloves to make sure that your life that we treasure is protected. Any user, any staff member that is at any of our facilities, after being tested for temperature, after being sanitized, if you don't wear your mask, you will be politely requested to leave. We do not want to be placed in a position where we have to do so. We care about your case. We know that your cases are delayed because of the level 5 lockdown that we had to deal with. But please work with us to make sure that all of us are safe from infection and spreading of COVID-19. So that is a direct question I can give on the disinfecting of offices. Now, there is an important from Brandon Ruade. I hope I'm pronouncing Ruade correctly. Brandon Ruade, who's asking, this should be the norm going forward, the future of effective dispute resolution. Absolutely. Absolutely. We fully support you, 100%. As I stated earlier, it is very unfortunate that the web-based processes and all other alternative systems, and also using the other offices of government to make sure that we expedite, that it is forced upon us because of COVID-19. This is what we ought to have done ordinarily. All our offices, all our homes must be disease, virus free. This is not just about COVID-19. This is about a matter of occupational health and safety for employees and the general public's health and safety. We have a duty as a constitutional state to make sure that people are free from hypertension, diabetes, TB, HIV, including COVID-19. The different platforms that we're going to use are going to become a new normal. We accept that. And we accept that fully and without hesitation. And we're going to ensure that it remains like that because there's a lot of benefit in it in terms of traveling cost, the risk associated with traveling, time, and money. So that to us is an important issue. Do we need permits to travel to the CCMA? This is Nandi Passon, who's asking if there's permits required to travel to the CCMA offices. At this stage, there is no requirement for permits to come to the CCMA. I wanted to deal with this question when it comes to the question of essential services. So please just bear with me. I will deal with that on the issue of essential service and permitted functions. What has caused us to delay? It is exactly the question that you are raising about the issue of permit. You will hear when I deal with the question and how we're going to deal with the issues of permit and who must issue that and when must that be issued. Let me deal with the issue of the condonation. There was a question that was asked that people were not able to refer cases because of lockdown level 5. People could not travel. And so as a result of that, cases are late. One of the critical questions you will note that we'll be raising later is that the Disaster Management Act, together with regulations issued in terms of it, there's no provision that suspends the application of other laws. This is a constitutional state that actually operates on the principle of constitutionalism. Therefore, the LRA continues to apply. So are the rules issued in terms of that. We have also noted that some of our users want to claim the benefits of the COVID-19 delay, even if matters were referred before lockdown. Now, the issue of referral within 30 days is a matter that is provided for in terms of the Labour Relations Act. It is a statutory issue. It is a matter that is contained in our rules. For us to adopt a different approach, you will need to change the statute to do so. But we are not oblivious of the impact that COVID-19 has had. What we are going to plead with you, if your matter is late and it is due to COVID-19 level 5 or level 4, please apply for condonation. And the reasons that you must state in terms of Rule 9 is that I could not apply for or refer my case because I was prevented by lockdown. We want to isolate cases that came before lockdown and those that came during lockdown. So if your case is referred immediately after that, during lockdown, because remember that the referrals were not blocked using the electronic approach, but we do understand that some of our unsophisticated workers and others who do not have resources, they could not have gone to internet shops to ask for them to fax or to email certain documents. As a result, they could not do so. The data, of course, of the issue and when it arose will become important. But the easiest way to deal with that, once you are within the COVID-19 ambit, is to make that application for condonation in terms of Rule 9 and state that, for example, I was dismissed on this date and 30 days ended during the course of the lockdown. I could not refer because I wanted to fax, I wanted to do this. And as a result, I could not refer the case. May you please condone. And of course, comply with the other issue, the degree of lateness, reasons for lateness, which is going to be lockdown. And you can't delay so much beyond that period and still use lockdown. We don't want to allow space for these other applications that do not deserve the protection. So do apply and state in your reasons for lateness. It was due to the lockdown. We were told to stay at home. We could not get out of houses. and I had no other materials. That's why I'm late. That's all you need to do, because we cannot deviate from the application of law as a result of these applications. Now, there's a question by Bra X Ngonyama saying, how do we deal with Rule 25 and Section 189A after lockdown? It's the same normal process that we follow. If you want to apply for Rule 25, which is the application for you to have legal representation, I did state earlier on, all applications that can be dispensed with purely on paper must be submitted in the ordinary process using the ordinary documents for it to be considered. Once your application in terms of Rule 25 is made, even is made today, is made next week, it will be allocated to a commissioner, and taking into account, of course, the answer from the other side. Then the commissioner will make a ruling. So there's no change in as far as the Rule 25 application is concerned. Whether the matter is done web-based, whether it's done at a different venue, Rule 25 still applies. It's only the platform that is changing, but the rules do not change. The rules have not changed. So bring an application in terms of Rule 25. With Section 189A, the same process of requesting for facilitation has not changed. And with this must not be mixed. There's two COVID or TERS institutions that exist. There's a COVID-19 related TERS, which is Temporary Employment and Employer Relief Scheme. And there's the normal one, which we provide assistance to companies that are in distress. So when you make an application, you must be clear which one are you applying to. If you are requesting relief because of COVID-19 impact, or ordinarily because your company is suffering a COVID-19 impact. But the referral and the time frames mentioned in Section 189.8A must still be observed. We have, I can share with you with pleasure, we have in fact enjoyed a web-based facilitation of 189A processes, including the matter of the SAA. We did that. So we are able to do so with that. So Polani, that is a direct response, that's the response that I'll give to you on the question. Now let me deal with the question that Polani Nzimande. I hope you are led to play it. Polani Nzimande said, when will the directives be published? It should be not later than tomorrow. In fact, the plan, I've settled them yesterday, it should be issued today. So we'll publish them on all platforms. Remember, we've got our Facebook, we've got our website, we've got our Twitter, we've got our app, we've got all of those platforms that we are going to enhance to make sure that there's more accessibility. So they are going to be published. Please read them and apply them. Okay. Now I've got another question that comes from Puseletso Grace Lamine, right? He says, what about bargaining councils? Thank you for the question, Puseletso. The bargaining councils, before the hard lockdown of level 5, the directives that we've issued, we've taken them to the bargaining council also to apply. And in as far as that issue is concerned now, when it comes to the bargaining council, everything else that we're talking about now are also going to be presented to the bargaining councils so that we are synchronized on how we deal with dispute resolution. We can't be not synchronized, that you enjoy all the benefits that we're talking about, but at the bargaining councils, you are unable to do so. Of course, bargaining councils have constitutions, they've got collective agreements, they've got other processes which we recognize. But if you look at the rules of the bargaining councils and how they operate, it's exactly like the rules of the CCMA. It's a replica of that with exceptions there and there. So in the main, the approach that we're taking is the same approach that the bargaining councils are going to take. And we're going to ensure that we share that so that we are in line. So do not panic about the bargaining councils, because I have seen also like the PSCPC and other public service bargaining councils talking about web-based hearings and things like that. So we're going to make sure that we're consistent when it comes to DR, so that we're not schizophrenic, that when you come here, this is how we do things, we get to the bargaining council, there's a problem. We're going to try our best to make sure that we are consistent in dealing with that. I've already mentioned in the opening of offices. Let me deal with the issue of the essential services, which will deal with the earlier questions that was asked earlier on about whether people need permits or not. One of the things that troubled us as a CCMA when we read the regulations, that we were not specifically mentioned as a permitted or essential services. And this created a confusion on whether matters can proceed. One of the biggest problems that we face in that time is that, number one, the CCMA is a public entity, which is part of the Department of Employment and Labor. And the DPSA advised us that when it comes to public service, the service delivered to our people must continue, which then meant the CCMA as a public entity must continue to operate, albeit limitedly. But the handicap that we had was that even if our offices are opened, our members of the public, when they look at the regulations, other than those permitted services and essential services, they are only allowed to move from home to work, or from home to buy groceries, or from home to buy medication, unless you are essential services. There's no express provision that says you can proceed and do cases. But when we read the latest regulations, and on our generous interpretation of that, and heeding the call of the DPSA, and our Minister of Labour asking us to ensure that we reopen our offices, it is expected that members of the public should be able to go to the bargaining councils and the CCMA without the required permits. Of course, there are certain exceptions where an instruction has been given, like attorneys and legal practitioners. The Legal Practice Council has said, head of those institutions must issue permissions for parties to travel. To the extent that that is applicable to all different institutions, you must be issued the permit for the safety of our users, for you to come to the office of the CCMA. But our view is that there's no permission required, because this is a public service function which is permitted. That must be done. You must proceed to the office of the CCMA and also to the bargaining council. Should any member of our public happens that our officers are making it difficult, or they are disallowed from coming to the CCMA and the bargaining councils, please alert us accordingly. I must also give an assurance that I have approached the Director General of the Department of Employment Labour and the Minister, that in cases where it is practical and necessary, if this becomes an issue, there must be a declaration made either by the DG or by the Minister saying, leave the CCMA alone and its users. They are permitted to operate. The workers and employers who want to come to the office of the CCMA do not need permission. And that's the view that we hold. So you are most welcome in the week of the 18th to come to the CCMA offices to deal with your cases. Now, I want to therefore speed up. First, the issue of essential services, I have to address that the CCMA offices hosts also, as part of an integrated institution, the essential services, right? Therefore, we have seen a new definition of what is called essential services. Firstly, it must be noted that the traditional meaning of essential services, as provided for in the Labour Relations Act, has not changed. Any definition outside that, either in terms of the Department of Trade and Industry or any other department for that matter, it shall be the essential services for the purposes of managing the disaster. But it does not mean that the meaning of essential services as declared there will have or will bear the same meaning within the context of the Labour Relations Act. It is important that we clarify that. I've dealt with the issue of face-to-face limited access, will be effective from the 18th of May, and we have declared that life comes first. Life is more important than work. So safety is important. Mask must be worn when you come to the CCMA. If you're not wearing that, you will not be allowed to remain or to enter our offices. Always wear a mask at all our offices. There will be sanitization that will be provided. There will be assessment which is done, which is quite compulsory. Our offices will continually be disinfected after each and every hearing that is going to be held. We will strictly observe the social distance, but observing social distance does not mean we must be antisocial. We will continue to be social, but within a distance that is prescribed. We will expedite the backlog of cases because we've also offered that we'll use weekends where possible for us to expedite the cases. There's going to be queue management also because of the social distances always have an impact of slowing the queue and all of that. So there's going to be queue management where there is such a queue. right? And when it comes to our conferences, we're going to use webinars and alternative methods of dealing with that. Now, there's a question that comes from Mafungwa Shetia, who says, employers are requesting us to force leave, sick and annual. I'll deal with that question when it comes to frequently asked question in Mafungwa. I will deal with that specific question within the precautions that I've said earlier on. There are a number of rights that are affected as a result of level 5. We have had to go and deal with other industrial actions. For example, what you don't know is that there are a number of cases that we dealt with that had unprotected strikes. And some of it affected like Pick and Pay, the distributors, workers, and unions, they were on strike, which would have meant that if we had failed to resolve that dispute, that Pick and Pay would not have food because there's no one providing or distributing food to the different outlets, and they were running out. So we had to wake up at 12 o'clock in the evening with the minister and go, and with our commissioners, we resolved that dispute. So the right to strike was limited as a result of that. Now, the issue now that we want to deal with are the complex questions, or what I call the frequently asked questions that we have to deal with. Number one, we are going to seriously pursue what we call the integrated approach, where the CCMA works closely with the UIF. We do not want to, when you come to the CCMA, you want to apply for funding, and we say, no, we don't deal with that, go to the UIF. There must be a system that where we can link with the UIF and then get the matter resolved. So this is the approach that we're going to take. In matters that we're going to deal with relating to the Section 189As, for example, we work very closely and we have a memorandum of understanding with the Productivity SA. I must say without hesitation that during these times, when we're dealing with mass dismissals, Productivity SA is one of the most relevant and needed institution for us to operate. This was confirmed by the CEO, Mutunyi Mutiba, and the chairperson of Mtunzi Mtwaba, the chairperson of the Productivity SA, on how it is important for productivity to be productive so the country can be productive. And this is the partnership we want to entrench to make sure that when dealing with job losses and turnaround solutions that Productivity SA provides, that we do so. So Mtunzi and Mutunyi, we are very clear about this one, that we're going to entrench and ensure that our relationship works so that to the extent that we can, we must turn around those companies that are in distress, that we ensure that the production and productivity and the alignment of policies like Mutunyi said in his article, that it is done. It is a very important process. So we're going to do so with that partnership, of course, together with the UIF, and also because they are part of the TERS process that we're dealing with. And the Bargaining Council, close work, I've dealt with that and the issue of venues. Now, one thing that is important that I must deal with on some of the questions and the issues that we've gotten, I want to make a plea to our employers also, that while we know that companies close, while we know that some retrenchments do happen, but when we notify workers that you're not going to pay them for whatever the reason, that we're going to retrench them, I'm asking that we do that with dignity. Let's do that with dignity as our Constitution expects us to do. Because when you're sitting and you get a WhatsApp that says we won't pay you in 2 days, when you're sitting, you get an email, we will be retrenching you in 2 weeks' time. I do not think that's the dignified approach. Because if there's anything that poses, that is a direct assault to dignity, is to be unemployed. And the manner in which we communicated, in how we deal with that process, it has to be compliant with law, because Section 189 tells you how we must deal with these things. But to receive such devastating news on a WhatsApp or an SMS, which gives you a day or two, it is devastating. I'm asking that we exercise Ubuntu. Let's exercise Ubuntu in how we deal with issues of closure of businesses and dismissals of any form. The process and approach must be dignified. Let's follow that, because for a person to be told at 9 o'clock in the evening, like some of them call me in tears, that I have no employment, I just got a letter, I was not spoken to. I was not in the meeting. They said it's done. You still have to go and break the news at home to your loved ones. It is a very difficult circumstance to be at where you do not know how you're going to pay school fees, how you're going to pay the house bond, how you're going to pay for that car, the groceries, medical aids, because your source of income is now gone. That is a painful experience that we do not wish for any person. Even if it is correct, it is unavoidable. But when we deal with it, let's deal with it hard and deal with it with dignity. That is the call that I'm making. Now, there's a question that businesses in distress and the inability to pay salaries to staff. What should employers do? Please, urgently, approach the Department of Employment and Labor. There's a link that you have to use, and there's certain information that is required. When you apply, do not just apply for the company to be assisted in terms of distress. Do it for employees also, because the principles of dignity that I spoke about, of people being hungry, having no food and nowhere to go because there are no salaries, it is one of the most devastating, dignity-affecting issues that you can ever imagine. So when you make an application for relief fund with the UIF, there's a COVID-19, the president made 500 billion rand available for assistance in the different ministries, but particularly this one. Please approach the COVID-19 TERS. That's what it's called, COVID-19 TERS. It's a COVID-19 TERS. So use that and apply urgently. We have seen that people have been receiving money already coming from COVID-19. While that is located in the UIF, in the Department of Employment and Labor, we encourage that you do your online application to make sure that workers have salaries and the company is being dealt with. There's a specific question about the termination of fixed-term contracts before actual expiry. There's two parts to that. It's a technical question. Ordinarily, there's something called the sanctity of contracts. This means that if we agree that we're going to be contracted for 1 year, stick to the 1 year and let it run. The issues of whether that can be renewed, that's a different debate that can be dealt with in terms of Section 186. But any premature termination of a contract is a termination of a contract called a dismissal. So once the contract is terminated prematurely, while we see those cases coming through, by the way, that is a matter that is justiciable at the CCMA. It is a referral in terms of Section 186 read together with Section 108, capital letter B. That is the premature termination of the contract. I know that those that can, some of them take a lawful approach, they call it an unlawful termination of a contract and claim damages. Yes, while I don't recommend that, that is done at the labor court. It's a longer process, it's more expensive. But any premature termination of a contract remains a termination of a contract. It is a termination contemplated in Section 186. It is a dismissal. Whether such a dismissal is fair or not, it depends on the facts that you're going to present to the commissioner. And the commissioner shall make a decision in terms of the evidence that is placed before him. I do not think that it would be appropriate for me to make any call on whether it is fair or not. But yes, that is how it's dealt with. That's how it must be approached. There's also the question that was asked whether an employer can impose leave on an employee. Please refer to Section 20, subsection 10, paragraph B of the Basic Conditions of Employment Act. It does state, in the absence of an agreement, an employer can direct on when an employee must take leave. But I'm giving this a general response because that's what the Act says. There are different circumstances that we have witnessed where the issue of force is used, where there's no attempt to agree, where in some companies where people force people to take leave during lockdown because they're trying to deal with a beautiful balance sheet. That's not a proper purpose for which to do this. Leave is a statutory requirement. It is a rights issue. Now, practically, if you force an employee to take leave during lockdown, what must they do? Where must they go for leave? Because leave is about rest, it's about vacation. But it can't be done solely to say, I don't want to leave credit into my balance sheet, therefore take leave and do it by gun. We must avoid such approaches. and take the consent approach, which is Ubuntu and the one that is constitutionally correct. Now, some employers apply the no work, no pay. You see, the no work, no pay, I must deal with this just quickly. I know we've run out of time. That when it comes to working from home, for example, or remote working, let's call it remote, because remote, you can be in a restaurant, well, they're closed now. You can be at any other than home, but working away from work, remote working. Please, organized labor and business, please develop guidelines before you implement these issues. Because when a worker gets an advice from the World Health Organization, our Department of Health says, if you feel you've got COVID-19 symptoms, then self-quarantine. If they self-quarantine because of that call, then they are not paid because they complied with the national call. There's a contradiction. We must adopt an approach that is transparent, that is consultative, that ensures that people understand that the principles of working remotely are established and known by the employer and the employee, that is applied in accordance with that, so that if it's not applied in accordance with that, then you can consider using corrective measures. Penalty matters must be the last resort. But you do find cases where there's non-compliance, and even in some cases where it is correct, where a person is self-quarantined, that they are not paid salaries because they were not at work. All disputes of pay, deduction, no pay, and no work, no pay, can be sent or referred to the CCMA for a commissioner to make that decision. Now, there's another interesting question that was asked by one of our commissioners in terms of the whether employees can be forced to sign an exemption or indemnity or indemnifying the employer in terms of compliance with employment law. Generally, you cannot give away your employment law rights because they are statutorily based. But there are processes in terms of Section 40 of the Occupational Health and Safety where the minister can actually exempt employers from complying with certain provisions or all of the provisions of the Occupational Health and Safety Act. We recommend, because it's a technical question, we cannot just have a yes or no answer. You have to take into account all the totality of factors, whether there's been an exemption, whether there's been application, whether there's a collective agreement, whatever the case, that makes an employer not to comply. But it can be done by force without following those exemption processes that are prescribed in the Occupational Health and Safety Act. Workers cannot, in terms of the LRA and the basic conditions, be made as a condition of employment to give up the employment law rights. All of them that are mentioned in the Section 2, I think, of the Minimum Wage Act and the basic conditions and the list of the employment law cases that are stated there. Now, let me deal with the other questions that may be remaining here. Now, we have attempted to respond to all the specific questions that we have been raising, and we see that the questions are still coming through. The commitment that we're making, because my team is telling me that I've run out of time, that all the questions that we have not responded to, that we are seeing on the screen, we are going to respond to them. You will note that the CCMA have what we call information officers also. There's only 4 of them, and they deal with 2,000 plus cases per day. It is my intention to increase the capacity of that desk so that we can try to achieve a 48-hour turnaround time in responding to your questions. Because I do understand and appreciate with my executive team and the governing body that when it comes to fair labor practices as protected by Section 185 of the LRA and the Constitution in Section 23, that it must be dealt with expeditiously and effectively. We're going to increase that capacity. But I do undertake, on behalf of my team, that all the questions that have been raised will definitely be responded to on the different platforms that we have raised. And our plan, of course, is to have a monthly session of this nature where we interact live and directly with you on the question that you raise like we did today. And I can assure you, moving forward, that the questions that we'll be dealing with in future or the sessions we're going to have, they are going to be theme-based. It's not going to be the general one that we're talking about now. For example, we will say that in the next month, we'll be dealing with large-scale dismissals and small-scale dismissals in terms of Section 189A. We will bring directives, we will bring case law and the approaches, tiers, COVID-19 and general tests. So when you come to this site, at least you will know what to expect, and we will also ensure that we pronounce the theme before the day so that all questions that we get prior, we will deal with them during that session. If the need arises, particularly if it is by public demand, we will consider if we should not extend the time in dealing with that, because we have noted with serious interest that our users in the labor market have taken special interest in this address that we did today. It was the first time that we do this as the CCMA, but given the response and the interest we've seen, we've taken a decision on the spot. It's going to be done monthly. There's others we're going to do quarterly, so that as things happen at the CCMA, new directives, new rules, new case law, everything that happens, that we tell it to you live, that you know what is happening, you know where to go, that all the promises that we've made today on the venues, on the web-based, will give you results on how well we're doing. And I'm happy to tell you that at this stage, there's no single employee of the CCMA, and supported by our association called the CSA, in ensuring that we give the support to our workers, that no single employee has COVID-19 infection. We are still sitting at 0, and we want to keep it at 0. Even if there's any one of our workers, any one of our employees or commissioners who may present himself with COVID-19 positive test, we will not treat them badly. And I'm making this call that when it comes to COVID-19, it is a constitutional imperative that we do not stigmatize it. We know what we had to deal with when it comes to HIV and AIDS. It was highly stigmatized. But let us destigmatize the coronavirus. It is a disease that is manageable. More than 3,000 people have survived COVID-19. Let's give the support. Even if we discover at our workplace, when you come to our offices on the week of the 18th, that you have COVID-19 on the spot, we will assist in self-quarantine. We will follow process that is recommended in ensuring that you get treatment and proper support. But there is no negative stigma that any individual, not in the office of the CCMA, that will be treated negatively because you tested positive for COVID-19. That we assure you. So in closing, on the 18th of May, we are back. It's time to dispense justice. Thank you for the time that you spent with the CCMA family. We will definitely ensure that as we pursue our new strategy, as you see in my background, that says imvuselelo, the revival. What this effectively means, we are more than 25 years into democracy. We have passed one of the best constitution and the best employment law. But the best application of any employment law is about it being properly applied. All the hours that we do as the CCMA together with the bargaining councils, they will mean nothing if they have not been executed. The commitment that the CCMA is making, every award that we've issued, every dispute that has been resolved, we shall see to it, in partnership with the Labour Court and the sheriffs, that those awards are fully implemented. Because an award that is not implemented does not mean anything. What we mean with our new strategy of 5 years, that we are reviving the spirit. What we are reviving, esikuvuselelayo, it is our ubuntu bethu. I am because we are. That is our slogan. As you can, I am because you are. I do not exist alone as an island. The CCMA does not exist as an island. We exist in the family of nations, in the environment of other institutions and companies. We are going to revive the spirit of our constitution, as the ministers and the president have said, that we as a people, recognizing the values that underlie our constitution, of ensuring that there is dignity, there's a recognition of freedom of rights of people, recognizing our history and taking our rightful place in the family of nations, that we implement our laws and become a constitutional state as we are, that all rights that are entrenched in any statute, we must revive our spirit and Ubuntu Betu and make sure that we treat people with absolute dignity and recognitions of the freedom that we enjoy. Therefore, it is our task to revive you, to revive the spirit on how we are as a nation. COVID-19 is an uninvited guest. It will not take over our lives. As John Donne said, that death be not proud. It may have killed members of our family. Some of them are now in hospital. Some of them are leaving us as we speak. But we will flatten the curve because we are a nation of winners. We are a revived nation. Thank you very much.